So tonight we are joined by an esteemed guest, Terry Rempel, who holds a PhD from the University of Exeter and also a writer and an independent research consultant specializing in forced displacement in Palestine and Israel. He's also a founding member of Badil Resource Center for Palestinian Residency and Refugee Rights. Um, so thank you very much, Mr. Rampel, for joining us tonight. We are happy to see you together with us here. Uh, just one reminder before we start. Our participants can write their questions in the chat bar to Africa Vakfı account, and then I will collect them and ask our guest as we do in every session. Okay, Mr. Rampel, the floor is yours. You need to unmute yourself.
Uh,
Okay.
Sorry about that. First of all, thank you for the invitation. And I hope you all have had a productive seminar to date. I have been asked to share some thoughts on three interrelated concepts, which are the title of this section, International Protection, Registration, and Return, as they relate to the specific situation of Palestinian refugees. Just in terms of some brief definitions before we start. International protection, as I will use in this lecture, refers to the protection accorded by the international community to both individuals or groups who are outside their own country, who are unable to return because they would be at risk there, and whose own country is unable or unwilling to protect them. Registration generally involves the recording, verifying, and update of information on individual refugees for the purpose of protecting them, providing assistance, and importantly, seeking durable solutions to their situation. And finally, return, which is one of the primary and preferred durable solutions, as you all know, involves the voluntary repatriation of refugees to their country of origin. So in the time that I have here this evening, I would like to provide some more specific comments on each of these concepts as they relate to Palestinian refugees, on how these concepts are dealt with in the literature on Palestinian refugees. And finally, in each section, I would like to end with some brief reflections on some of the ways in which each of these concepts appear in a small subcategory of literature on Palestinian refugees that are part of what Edward Said described as a counter-archive of settler colonialism on Palestine, in Palestine. Now, I have been familiar with some of this literature from the counter-archive from my earliest engagement with the Palestine question in the 1990s. And it was this literature that helped me understand, for example, that the Palestinian refugee problem, as it is often referred to, far from being the consequence of two big bangs, namely the 1948 and 1967 Arab-Israeli wars, as Rosemary Syed has observed, was an ongoing problem that began before and continued after the two major wars and continues up until today, as we see in the form of Israel's genocidal campaign in Gaza. But as I have revisited this literature in the last few years, in dialogue with a much broader canon of research, I have come to understand this relatively less known body of work on Palestinian refugees, that is to say, research found in the counter archives, and the context in which it emerged in ways that I neither had the eyes to see, so to speak, nor the tools to discern how rich indeed this relatively small body of work is, and how informative it is, I would argue, for the situation of Palestinian refugees and the Palestine question today. By no means should my intervention this evening be regarded as a deep dive into refugee protection, registration, and return. Indeed, given the size of the task that I have set out, my remarks will be somewhat cursory rather than comprehensive, but hopefully will nonetheless provide sufficient fodder for some discussion and critical debate. Now, in terms of how the lecture will unfold, I want to begin with some general remarks on the Palestinian refugee regime. That is to say, the set of international institutions responsible for Palestinian refugees and the primary instruments which reaffirm their fundamental and inalienable rights. This provides the necessary background for discussion of each of the three concepts that are the focus of this lecture. In contrast, however, to the order in which these three concepts appear in the title of this session, I would like to begin with return, in part because of its centrality to the Palestine question, refugees in particular, but also because it helps to set the stage for the discussion of the first study in what I refer to, using Edward Said's term, the counter-archive. This will be followed by some remarks about international protection of Palestinian refugees and their registration as refugees, to which I will append a necessary discussion about refugee definitions, which will, in a way, bring us back to some more immediate concerns. So let's start with the Palestinian refugee regime. What do I mean by this? The majority of Palestinian refugees fall within a distinct international regime of institutions responsible for their protection and provision of assistance and related instruments which reaffirm some of the fundamental or inalienable rights of the Palestinian people. Palestinian refugees, it should be noted, also fall within a number of regional refugee regimes within and beyond the Arab world. However, for reasons of time, I will limit my remarks to the international level. The distinct international regime for Palestinian refugees that I am referring to here is comprised of two major UN institutions and a handful of related General Assembly and Security Council resolutions. The UN Conciliation Commission for Palestine, or UNCCP, of which Turkey was a member alongside the United States and France, was established in December 1948 to facilitate the implementation of General Assembly Resolution 194, which includes directives on the return of refugees to their homes, compensation for loss and damage, and the resettlement of refugees not wishing to return. The resolution also directed the Commission to maintain close cooperation with the UN Relief for Palestine Refugees, or UNRPR, which we will return to shortly. Resolution 194 might be described as the UN's second peace plan for Palestine and a response to the collapse of its first, Resolution 181, or the Partition Plan. The UNCCP essentially inherited the mandate given to the UN mediator for Palestine, who incidentally in turn had succeeded the UN Palestine Commission, the body that was set up to facilitate the implementation of Resolution 181, along with any other tasks identified by the UN General Assembly and Security Council. As such, the UNCCP was not an international refugee agency per se. It had a much broader mandate. However, the Commission also established a number of subsidiary bodies to facilitate the implementation of Resolution 194, most of which related to the refugees. These included an economic survey mission, a technical committee, a refugee office, a committee of experts on compensation, and a technical and valuation office. So, to abbreviate a much longer story, the UNCCP effectively ceased its diplomatic and political efforts at the end of 1951 and completed thereafter work on the identification and valuation of refugee properties, a topic which is covered extensively by Michael Fischbach. More general coverage of the UNCCP's diplomatic efforts can be found, among others, in early work by David Forsyth and some 2 decades later by Neil Kaplan. No longer operational today, however, the Commission still continues to submit an annual report to the General Assembly, stating that it has, quote, nothing new to report, unquote. As we will see later, however, the UNCCP is nevertheless critical, I would argue, to understanding UNRWA, in particular, why and how this refugee agency differs from UNHCR, the High Commissioner for Refugees. So the second UN body that's part of the international regime for Palestinian refugees is the UN Relief and Works Agency for Palestine Refugees in the Near East, or UNRWA, which I am sure you all have heard about, especially in relation to events in Gaza. UNRWA was established in December 1949 on the recommendation of the Economic Survey Mission, one of the UNCCP's subsidiary bodies that I referred to earlier. UNRWA succeeded the UN Relief for Palestine Refugees, which was set up at the behest of the UN mediator during the 1948 war to facilitate cooperation and oversee the delivery of relief by three major non-governmental organizations: the Red Cross, the League of Red Crescent Societies, and the Quakers. General Assembly Resolution 302 accorded UNRWA an expanded mandate to facilitate the direct delivery of relief and oversee a works program that aimed to facilitate the economic reintegration of the refugees in the Arab region through repatriation or resettlement. UNRWA's activities have nevertheless evolved over the past 75 years in response to changes in the agency's operational environment, including in its 5 areas of operation: the West Bank, Gaza Strip, Jordan, Lebanon, and Syria, the wider Arab region, and globally, both in terms of its primarily Western donors, as a member of the UN family, and in terms of the evolution of humanitarian norms. It has also evolved in response to the changing needs of refugees themselves. Now, you've already heard about UNRWA in detail from Jalal Husseini, so I won't go into detail here, but some additional references include major works by Benjamin Schiff, an edited collection from Sari Hanafi, from whom you will hear from tomorrow, I hear, along with Leila Halal and Lex Tackenberg, and a more recent volume by Anne Irfan. However, I do want to draw attention to one significant development that is of relevance to today's lecture, which is the agency's development and mainstreaming of a protection program over the last 20-odd years. UNRWA's beneficiaries, it should also be noted, have also expanded over the course of the agency's history, most notably in terms of numbers, with the extension of assistance to Palestinians displaced for the first time during the 1967 war and by subsequent hostilities. Resolution 302 also established an advisory commission, of which Turkey is a member, and further instructed UNRWA to consult with the UNCCP with regard to their respective tasks under Resolution 194, paragraph 11 on refugees in particular. Now, there are many other interesting details that could be addressed about the UNCCP and UNRWA. However, one important point to draw a comparison with UNHCR is that the Palestinian refugee regime, unlike the international refugee regime, about which I will say a few words, essentially shared responsibility for Palestinian refugees along lines that were roughly divided between the UNCCP's diplomatic or political work and the technical and implementation work of UNRWA. These lines, however, it should be noted, were far from clear at the beginning and a source of contestation during the regime's early years, and by some accounts, one of the reasons for the UNCCP's operational demise. Another major difference between the two regimes, Palestinian and international, aside from the respective mandates of the UNCCP, UNRWA, and UNHCR, and how the related activities of each of these three agencies evolved over the years, is that the status of refugees under the Palestinian regime is not governed by an international treaty like the 1951 Convention relating to the status of refugees. As for the major resolutions of relevance to the Palestinian refugee regime, for reasons of time, I will only mention that in addition to General Assembly Resolutions 194 and 302, which I've already talked about, Other major UN resolutions include Security Council Resolution 237 of 1967, General Assembly Resolution 2252 of 1967, which relate to, respectively, the solutions for and assistance extended to refugees from the 1967 war, General Assembly Resolution 37120B of 1982, which further extended assistance to Palestinians displaced by hostilities subsequent to the 1967 war. One might also mention Security Council Resolution 242 of 1967, General Assembly Resolution 3089D of 1973, which clarified the refugee provisions in Resolution 242, and General Assembly Resolution 3236 of 1974 on the inalienable rights of the Palestinian people, among many others, which are relevant to Palestinian refugees, but are not as such directly related to the Palestinian refugee regime. Now, it is also important to note, as I mentioned earlier, that some Palestinian refugees fall within the mandate of the international refugee regime. That is to say, the regime comprised of UNHCR and the 1951 Refugee Convention and its 1967 protocol. In short, these include a relatively small number of Palestinians who are outside UNRWA areas of operation and in need of international protection. While refugees from the 1948 and 1967 wars fall under Article 1D of the Convention, those displaced subsequent to the wars fall under Article 1A2. UNHCR statistics for 2023 identify around 41,000 Palestinian refugees, 12,000 Palestinian asylum seekers, and close to 3,000 other Palestinians of concern to UNHCR. So compared to the roughly 6 million Palestine refugees registered with UNRWA, this is a relatively small number. A detailed breakdown of these figures, including by host countries, can be found on UNHCR's website. So today there is what might be described as a geographical, as compared to a functional, division of responsibilities between the two refugee regimes. One might call it a hybrid regime overall. However, the relationship between the two component regimes, Palestinian and international, and what this meant for the protection of Palestinian refugees was not always clear. Indeed, there is still some debate among scholars today. And this has necessitated over time not infrequent dissemination of press releases and notes to clarify which regime is responsible for which refugees in what ways. And this has most often occurred during major emergencies in the Arab region. And now, finally, it should be noted that from a research perspective, aside from the growing body of literature on the status of Palestinian refugees under the Refugee Convention, especially in the last 25 to 30 years, much less is known about UNHCR's role, especially before the 1990s, and Palestinian refugees who are outside UNRWA areas of operation. So let's turn then to a discussion of return. Of the three concepts covered in this lecture, return is probably the most emotive, not least of which is due to the fact that it impinges on the identity of Palestinians and Jewish Israelis alike. Given the relationship between return, international protection, and registration, moreover, the emotive atmosphere that inevitably envelops discussion of return also helps to explain some of the controversies that often swirl around discussions of international protection of Palestinians and their registration by international bodies. Much of this debate in the literature on Palestinian refugees initially revolved around Palestinian Arab claims that Zionist Israeli forces had expelled the refugees, and Zionist Israeli counter-allegations that the refugees left at the behest of Arab leaders who promised a swift return at the end of the war. In the late 1970s and early 1980s, this debate, one could argue, shifted to arguments in law journals around whether Palestinian refugees had a right to return under international law. Arguments which were revisited and revised in the context of negotiations between Israel and the PLO that began in the 1990s. So we see a much larger proliferation of literature on the legal rights of Palestinian refugees, the right of return in particular. More recently, there has emerged a growing body of largely gray literature relating to the practices of return, including initiatives that relate to the rebuilding, for example, of destroyed Palestinian villages. And finally, for the most part, scholars have focused on efforts to resolve the problems of Palestinian refugees and the problems that the refugees pose for states through diplomatic negotiations. Unofficial efforts, of which there have been many, and of many different types, have to date received relatively little sustained attention. One can identify at least three different approaches to the return of Palestinian refugees since the 1948 war. These include spontaneous return, which took place for brief periods after the 1948 and 1967 wars until Israel sealed its de facto borders. Humanitarian return, mostly through the reunification of divided families, and negotiated return after the 1948 war under UNCCP auspices, and more recently in the 1990s and 2000s under American mediation. During the first set of UNCCP talks, the Commission tried to facilitate the implementation of paragraph 11 of Resolution 194 through what it called a process of subdividing the refugee issue. This included an initial attempt to distinguish between refugees who wish to return and those who wish to remain in the countries of first refuge or resettle elsewhere. A second effort sought to build confidence among the parties by distinguishing between interim and final return, with the former focused on the return of small subcategories of refugees, such as the owners of orange groves and respective laborers. A final push, and this is 1951, saw the development of a pilot project for return and resettlement of roughly 20,000 refugees each, that is to say, for a total of 40,000 refugees initially, which initially combined elements I referred to earlier, focused general conflict in Palestine. However, more recent research in Engdahl, who also covers through the 1964, focused on UNCP diplomacy on Palestinian refugees. The second negotiation, known peace process or off process, that was initiated in the early 90s, established separate negotiating track for 1940 refugees or bilateral between Israel and the PLO, and a on 67 places, that is refugees, 1964. And this process was tight, involved Israel, Egypt, and these processes were initially set forth in the 1978 Framework Agreement for Peace in the Middle East to Egypt and Israel. And we can say that two presidents, 1940 refugees, 1967 refugees,
I think he's having a connection problem. Um, okay, so apparently he's gone. Oh no, he's here. Um, Terry, if can you hear us?
I can hear.
Okay, because we have lost you. Okay, we can't hear him now.
Hear you. Can you hear me now?
Yes, we
Hello?
can. Yes, we can hear you now.
Good. So I look at just with the negotiations during this process. As the process of refugees in two, 148 refugees, 160 refugees. But it also bifurcated the other way between political negotiations goes on and humanitarian problem or took multi and in the literature on Middle East peace process focuses on negotiations more generally. However, there is quite significant literature on the refugee working group, journal articles, much of which is either by former gavel holders, working group, Robinson, or by academics and as Rex Bryan and the latter authors also add a number of volumes of research for Canadian government-sponsored Track 3 mechanisms on Palestinian refugees. This second period of talks on Palestinian refugees also spawned a much broader literature, including a significant number of conference publications, an increasingly vast body of literature by NGOs, including organizations such as Shamel, Badil Resource Center, the Palestinian Return Center, and Zohrot, just to name a few. This literature was also notable because of its focus on the legal aspects of return, the comparisons it made between Palestinian refugees and durable solutions for refugees elsewhere, Bosnia and Herzegovina in particular, and because of its focus on the practicalities of return. On the latter, the practicalities of return, the pioneering work of Salman Abu Sitta deserves special mention. It was the emergence of this literature that led Michael Kagan to observe that there was what he called a relative decline in Palestinian exceptionalism in the field of refugee studies, in which the Palestinian case had long been treated as sui generis. The gradual demise of political negotiations and new rounds of armed conflict in the region that followed, moreover, appear to have spawned an even greater body of research, such that one might point, given its breadth and scope, to the emergence of a putative subfield of Palestinian refugee studies. Now, the political obstacles which scuppered both rounds of negotiations on Palestinian refugees are well known, namely the Palestinian demand for return and Israel's opposition to it. So there's no need to go into further detail here, aside from the fact that it is important to note that there are considerably more diverse perspectives among individuals and segments of Palestinian and Israeli societies over time that tend to be overlooked in much of the literature on the negotiated return of Palestinian refugees. And Norma Salha is among the various scholars that have examined both Israeli and Palestinian views on return in some detail. It is also important to note, in light of the last 11 months in Gaza, that with the adoption of a rights-based approach to the refugee issue, promoted in particular by NGOs, as Nurit Gal has observed, Israeli officials concluded that a solution to the refugee problem, i.e. one in which their return would be resolved through the creation of a Palestinian state in the West Bank and Gaza Strip, assuming here that Israel was serious about Palestinian self-determination, this meant that a solution to the refugee issue was no longer possible. In other words, because it was a right, it was not negotiable, and therefore a solution was not possible from Israel's perspective. In addition to factors addressed elsewhere, this perhaps helps to further explain Israel's genocidal campaign in Gaza, of which the forcible and repeated displacements of Gazans, most of whom are refugees from the 1948 war, has been and continues to be, as we have seen this month, a major element. As one official in the Israeli Foreign Ministry observed during the early days of the Palestinian refugee problem, as Noor Masoha points out in his book on Israel's politics of denial, quote, "If you can't resolve it, dissolve it." Here now, I would like to briefly turn for the first time to the consideration of refugee return in what Edward Said described as the counter-archive of settler colonialism on the Palestine question. I have chosen to focus on the work of Palestinian scholar and statesman Fayez Sayegh here, who is perhaps more well known for his conceptualization of Zionist settler colonialism that was published in the mid-1960s by the PLO's Research Center. One can find traces of his conceptualization of the Palestine question, however, in his much earlier work published in the early 1950s on Palestinian refugees, just after the collapse of UNCCP talks. The monograph was Sayegh's indirect response to Joseph Shechtman, the European expert on population transfer and protege of revisionist Zionist leader Vladimir Jabotinsky, and the arguments that Shechtman made, including the allegation that refugees left at the behest of Arab leaders, in his own monograph on Arab refugees that was published at the same time that Sayegh's was published. Now, Sayegh's primary concern in his 1952 monograph on Palestinian refugees was to place the refugee problem in its proper context, i.e. that of Zionist settler colonialism. While Shechtman's allegations about Arab orders were subsequently shown by Walid Khalidi and Erskine Childers in the 1950s and 1960s to be without evidence, Shechtman's framing of the root cause of the refugee problem, namely as a consequence of war between nations, more specifically between Jewish and Arab nation states, has survived, not least because it is the fundamental paradigm through which refugee problems around the world have been studied, although this has begun to change in recent years through various efforts to decolonize the field of refugee studies. To conclude this section, Sayegh's work raises a number of basic questions, such as what would return look like in a context of decolonization and liberation? What challenges might arise that are specific to settler colonial contexts? What comparisons can we make, and what lessons can be drawn from other settler colonial states? And can settler colonial states be effective mediators in the context of decolonization of other settler colonial states? Here I am thinking both in particular of the role of the United States and Canada in the Middle East peace process. So let's turn then to international protection. It is hardly surprising that international protection, physical protection in particular, given the frequency of armed conflict in the Arab region, whether inside Israel in the 1967 OPT or in adjacent Arab states, which host the vast majority of Palestinian refugees, has been a long-standing issue of concern. Indeed, the emergence of what scholars and activists now refer to as a protection gap, that is to say, inadequate, ineffective, or the absence of institutions and instruments to protect refugees, occurred more than 7 decades ago after the UN General Assembly decided to devolve UNCCP responsibilities for the implementation of Resolution 194 to the parties, which led to the closure of the Commission's Refugee Office and the cessation of what appeared to be, from the historical records, an emerging program for the international protection of Palestinian refugees as far back as the early 1950s. It is somewhat of a puzzle, then, that academic discussion of international protection of Palestinian refugees, researched by Abbas Shiblak and Lex Tackenberg in the 1990s, being among the earliest published studies in academic work, is relatively recent, notwithstanding somewhat earlier initiatives by the General Assembly in the 1980s to address the protection gap in UNRWA areas of operation through an expansion of agency activities, which we will return to shortly. Now, the lack of adequate attention, whether academic or at the policy and operational levels, is further puzzling given what appear to be frequent acknowledgement of a protection gap that can be traced all the way back to UNRWA's 1952 annual report to the General Assembly, which included an annex that summarized the status and rights accorded to Palestinian refugees in each of the agency's areas of operation. The not infrequent issuance of press releases and notes by UNRWA and UNHCR, as mentioned earlier in relation to their respective responsibilities and their mandates with respect to Palestinian refugees, further evidence ongoing awareness of an international protection gap. Discussions within UNRWA about whether to issue individual identity cards to Palestine refugees acknowledging their status as refugees, as Ilana Feldman points out, recommendations to address the gap by the UN's Joint Inspection Unit and discussions among Arab experts in the 1980s, the issuance of conclusions on protection of Palestinian refugees by UNHCR's Executive Committee into the early 1990s, up until the Oslo process began, annual debates on UNRWA operations in the General Assembly, and not infrequent mention by non-governmental organizations and activists all seem to underscore widespread awareness of the problem. Well, all of these developments have provided fodder for the more recent discussion of how to address the gap that Palestinian refugees confront. It was perhaps the broader turn towards protection among humanitarian actors after the end of the Cold War, coupled with the relative decline of Palestinian exceptionalism in refugee studies that I referred to earlier, that led to the production of both academic and non-governmental research on international protection of Palestinian refugees. It might be argued, though there is some lingering disagreement among scholars and activists, that the institutional aspect of the gap, created by the devolution of UNCCP responsibilities to the relevant state parties and the closure of the Commission's refugee office in the early 1950s, has essentially, if not always effectively, been resolved through UNRWA's development and mainstreaming of protection within the agency and across its 5 fields of operation. Conventional narratives trace the beginnings of UNRWA's protection role to the General Assembly resolutions first adopted in the early 1980s, which tasked the agency, in cooperation with the Secretary General, to monitor and report on the human rights of Palestinian refugees, with initial focus on Lebanon and on the 1967 OPT. Recommendations issued by a special representative of the Secretary General in the context of the first Intifada in the late 1980s further operationalized the agency's understanding of protection through initiatives such as the Refugee Affairs Officer Program, which was set up to monitor the humanitarian situation in the OPT and intervene with Israeli authorities when required. The second Intifada in the early 2000s and gradual demise of the political process between Israel and the PLO resulted in new or reinvigorated protection initiatives, including UNRWA's appointment of a senior protection policy advisor in 2007 and the establishment of a protection division in 2016. As noted earlier, unlike UNHCR, UNRWA is neither responsible for oversight of an international treaty with respect to Palestinian refugees, nor is the agency tasked with the development of a specific body of international law relating to their situation. However, in light of its mandate, a number of human rights treaties, including the Convention on the Rights of the Children, the Convention on the Elimination of Discrimination Against Women, and the Convention on the Rights of Persons with Disabilities, are of special relevance to Palestine refugees. More details about UNRWA's protection definition, functions, and challenges can be found, for example, in Lex Tackenberg's second revised edition of Palestinian Refugees in International Law, co-authored with Francesca Albanese, the current UN Special Rapporteur on the 1967 OPT, and from the agency's website. Now, this is not to say that the protection gap that has existed for the better part of UNRWA's existence has been closed when it comes to meeting the day-to-day protection needs of Palestine refugees and the long-term need for a political solution to the Palestine question, through which solutions for refugees can be found. Indeed, institutionally speaking, Damian Lilly, the former head of UNRWA's protection division, observes that the real protection gap Palestinian refugees face is not an international protection gap per se, but rather a durable solutions gap. by which I understand he means both the absence of a political solution to the Palestine question and the lack of a refugee agency with an explicit mandate to search for durable solutions for Palestinian refugees. Whether the day-to-day protection afforded by UNRWA is sufficient, moreover, appears to be a matter of contention between the agency and the refugees it serves. If one compares UNRWA's reporting on its protection initiatives with opinion surveys of camp refugees in UNRWA's areas of operation. Although, to be fair, this may also stem from somewhat different understandings about what protection is or should be, and about UNRWA's capacity to protect Palestinian refugees, especially those in the 1967 OPT. And while scholars and NGOs have examined the status and treatment of Palestinian refugees in UNRWA areas of operation, there also appears to be a paucity of good theoretical work that conceptualizes how international protection refugees can be assessed, notwithstanding UNRWA's development of indicators for its own operations. Using the framework formulated by Volker Turk and Rebecca Dowd, for example, which identifies three different types of protection gaps: normative, application, and implementation, one might argue that the most significant gap facing Palestinian refugees revolves around the implementation of relevant legal instruments and principles. Well, there are the obvious implementation gaps in major Arab host countries, for example, the various forms of discrimination that Palestine refugees face in Lebanon. The primary gap, I would argue, stems from Israel's denial of the inalienable rights of the Palestinian people, namely self-determination, sovereignty, and the right of refugees to return to their homes and properties. The overarching prohibition of racial discrimination and respect for the fundamental principle of equality, and the non-implementation of international humanitarian and human rights law in the 1967 OPT. Application gaps appear to be less severe. Major Arab host states are signatories to the relevant international human rights treaties. Now, it should be noted that while none have ratified the Refugee Convention of 1951, under Article 1D, the convention is not applicable to Palestine refugees in UNRWA areas of operation. More problematic, though, is the fact that the ratification of complaints procedures, which enable individuals to hold states accountable for the implementation of their obligations under relevant treaties, is especially low in the Arab region, and this includes the State of Israel. Finally, as for normative gaps, some of the most significant gaps in the Palestinian case, in particular, the legal implications of Israel's prolonged military occupation and its apartheid regime in the 1967 OPT, have recently been addressed by the International Court of Justice. What this will mean practically going forward remains to be seen, but what remains to be addressed, arguably by the court, although inferences can be drawn from its recent advisory opinion, is the apartheid regime on the other side of the 1949 armistice line, namely within Israel proper, which comprises the barrier to refugees wishing to return to their homes and properties from which they were displaced and dispossessed. Incidentally, proposals to the court to address this kind of a gap through an advisory opinion can be traced as far back as 1952. Equally, if not more problematic, normatively speaking, is the way in which the principle of self-determination was crafted to deny Indigenous peoples the right to self-determination in cases where settler colonies had achieved independent statehood, including settler colony states like the US, Canada, Australia, and New Zealand. Before examining how the international protection of Palestinian refugees has been dealt with in the counter-archive, it might be useful to briefly recount what we know about international protection gap for Palestinian refugees who are outside UNRWA areas of operation. As noted before, this involves a comparatively smaller number of Palestinian refugees who fall within the mandate of UNHCR, which is responsible for the implementation of the 1951 Refugee Convention. In terms of the three different types of gaps identified by Turk and Dowd, normative, application, and implementation, researchers, academic, and non-governmental alike have focused in large part on the implementation aspect, more specifically the interpretation of Article 1D of the Refugee Convention. While Tackenberg's research in the 1990s brought much needed attention to this issue, it is arguably through the subsequent work of NGOs, Badil Resource Center among them in particular, together with other scholars, such as Susan Akram, that much greater attention has been given to the status of Palestinian refugees outside UNRWA areas of operation, but also an effort to promote more substantive thinking about international protection in the Arab region, the 1967 OPT in particular, by Western states who were long reticent to substantive consideration of such protection. And to do this by promoting greater awareness about international protection needs of a much smaller and arguably politically less contentious group of Palestinian refugees residing in states signatories to the Refugee Convention. However, while there has been growing awareness of the problems in the Refugee Convention's implementation for Palestinian refugees outside UNRWA areas of operation in the last 20-odd years, including the development of a considerable body of jurisprudence, there appears to be little apparent change in state practice. The second revised edition of Badil's Protection Handbook, which surveyed 30 countries, for example, found that over a course of a decade, national practice had in fact become more complex and more diverse, amounting to 11 different interpretations of Article 1D. Moreover, as Israel's genocidal campaign in Gaza horrifically demonstrates, not to mention settler violence in the West Bank to give only one example, the strategy of creating greater awareness about the principle of international refugee protection by focusing on the situation of Palestinian refugees outside UNRWA areas of operation appears to have done little to shift international, i.e. Western attitudes about the international protection of Palestinian refugees and the Palestinian people more broadly in the 1967 OPT and the agency's other fields of operation. From my reading of the counter-archive literature to date, it seems that relatively few contributors have addressed the concept of international refugee protection. Admittedly, the literature that focuses on refugees within the counter-archive is relatively small. It also largely predates the turn among humanitarian actors towards protection in the 1990s, although there is some overlap with UNRWA's initial protection shift in the early 1980s at an operational level that I referred to earlier. One might also argue that relevant scholars were much less focused on the role of international, largely Western-based institutions like UNRWA and UNHCR in terms of their origins, and more focused on solidarity and related initiatives arising within and from the Third World. Nevertheless, notable among the scholars writing in this period was Anis Al-Qassem, an expert in international law and Secretary General of the International Organization for the Elimination of All Forms of Racial Discrimination, which was set up after the adoption of General Assembly Resolution 3379 in 1975, which declared political Zionism as a form of racism and racial discrimination. It was set up to conduct, support, and publicize scholarly research on racism and conflict with a specific focus on Palestine and South Africa. I'm particularly interested here in a paper by Al-Qassem prepared for a seminar sponsored by UNHCR and the San Remo Institute for Humanitarian Affairs on asylum and refugee law in Arab countries in the early 1980s. Al-Qassem wrote a paper on racial discrimination and refugee law. In the paper, he explained how the combination of settler colonialism and racial discrimination created some of the most damaging refugee situations in the world, not only through settler attempts to replace indigenous populations, but also through related efforts of settlers to secure their permanent domination, which necessarily entailed the denial of any and all rights that might contribute to decolonization and indigenous liberation. He further argued that this created special obligations for international bodies responsible for the protection of refugees, notably the preservation of the refugees' national identity and securing their voluntary repatriation. Al-Qassem further argued that UN bodies responsible for international protection of refugees should be empowered to initiate legal proceedings against the refugees' country of origin in order to establish state responsibility and to protect the right to return. A number of basic questions follow from Al-Qassem's paper to conclude this section of the lecture. What specific challenges does settler colonialism include the insatiable desire for land and the consequent focus on native elimination mean for international protection? What are the colonial origins and legacies of the Palestinian and international refugee regimes, both in terms of institutions and relevant legal instruments and principles? In what ways do they impact international efforts to protect Palestinian refugees today? And in what ways does a settler colonial state's past and present influence or affect its ability to protect refugees, especially those from other settler colonial states? Finally, registration and, by way of association, definition of a Palestinian refugee.
Terry,
Yes,
I'm so sorry, but we have like 5 minutes, okay?
you have 5 minutes.
Yeah,
Okay, so
then
let me just briefly summarize this section in 5 minutes.
all right. Okay, thank you.
So the basic point that I want to make in this section on registration and the definition of Palestine, of a Palestinian refugee, is that 2 points. First of all, some of the major issues that have arisen in terms of the registration of Palestinian refugees with UNRWA, which is the primary organization that registers refugees, relate to a number of issues. For example, gender-based discrimination. There have also been debates over the registration of descendants of Palestine refugees, questions raised about the registration of Palestinians who have become citizens of Arab states, notably in Jordan. However, I would argue that these issues, particularly those related to descendants of Palestine refugees and those who've acquired citizenship, fail to distinguish between the differences between UNRWA's mandate and UNHCR's mandate, and also fail to take in account the existence of two relatively unknown definitions, albeit draft definitions, that were prepared by the UNCCP, which is UNRWA's counterpart in the Palestinian refugee regime. Notable here is the fact that the UNCCP's definitions of a refugee, which were prepared for registering refugees eligible for repatriation and compensation, and a second definition, which would have registered refugees eligible for international protection pending a solution to their situation, are both of these definitions, draft definitions by the UNCCP, have elements that are similar to the definitions found in UNHCR statute and the 1951 Refugee Convention. So in this way, they are complementary to UNRWA's definition and help to explain why UNRWA's definition is different from UNHCR's. And this is because in the case of the Palestinian refugee regime, responsibilities for protection, assistance, and durable solutions were shared between two bodies, UNRWA and the UNCCP, whereas for UNHCR, all of these functions were placed under a single institution. Last comment then on the counter archive, and that's where I want to end with just some brief comments on one additional source. Here, I would like to turn to the work of Janet Abou-Lughod, the American sociologist who is perhaps more well known for her demographic studies, which marshaled empirical evidence about the impact of what she conceptualized as the process of conquest to colonization in Palestine in terms of the shrinking number of Palestinians in Palestine and the growing number elsewhere in the Arab region and further abroad, which she was able to document through review of a wide range of statistical sources and through estimations. Her related work, however, which situated the concept of a refugee within the concept of Zionist settler colonialism, is perhaps less cited, but arguably of equal significance. Abou-Lughod observed that the forced displacement of Palestinians could only be fully understood within the context of the denial of Palestinian self-determination by colonial powers was codification of religion/descent as the sole criteria for full membership and rights in a state. As she further explained, these mechanisms of exclusion, both global and national or domestic, made and arguably make it difficult to distinguish between refugees in a juridical or administrative sense and all other Palestinians. Put another way, Palestinians were and are a displaced nation, not a finite number of refugees whose problems can be solved individually. Drawing upon Edward Said's discussion of exile, Abu Lughod described Palestinians rather as exiles at home and abroad, the fundamental aspect of which was the lack of an option to return, even though exile did not necessarily extinguish their dream of return. Moreover, underscoring the differential status and treatment accorded by Israel to Palestinians within its areas, whether inside Israel or in the OPT, Abu Lughod further observed that their situation was similar to that of indigenous nations in the so-called New World settler colonial states, such as the United States and Australia, in that they were exiles on their own soil and in their own homelands. Thus, unlike the situation of refugees, that of an exile was neither transitional nor transitory, it was inherited, pointing out that even well-meaning persons had misdiagnosed the Palestine question. Abu Lughod concluded that until the situation of the Palestinian people was properly conceptualized, solutions to the Palestine will continue to evade us. Above all, and this is where I will conclude, it seems to me that Abu Lughod challenges us to rethink the context in which we have come to understand the so-called Palestinian refugee problem, in the sense of asking, a problem of what? Relatedly, what does this mean for the concepts, such as the refugee in particular, and comparisons that inform both academic research, policy prescription, and practice when it comes to addressing the problems of Palestinian refugees, from international protection to the return to their home? I'll conclude with that.
Okay, thank you very much. This was a great lecture. We enjoyed a lot. Um, I would like to go to the questions straight. Okay. Okay, so we have plenty of questions. Let me begin with this one. Taken into account several negotiations between Israel and the Palestinian side have been held, over the course of time, was there any genuine will on the side of Israel in any of these negotiations to accept the return of the Palestinians? If yes, in which talks and to what extent?
If the question relates to, in terms of genuine will, did Israel in these talks ever accept the right of return in principle? The answer is no.
Mhm.
If the question relates, if the question is, have there been efforts to somehow find a solution that would somehow accommodate for what might be called the right to return, and still preserve Israel fundamentally as a Jewish state, by which, from Israel's perspective, would mean a permanent Jewish majority, special privileges in certain areas, such as return and land and property rights, special privileges for Jews, then there are some initiatives that have tried to do this. Such as, for example, in the early period, Israel made an offer in the early 50s to allow, for example, 100,000 refugees to return, or to annex Gaza and the refugees in Gaza. Although I think there is a consensus among scholars that these were not serious offers. There was tremendous pressure on Israel to somehow come to an agreement, and Israel was also in an early stage where it needed to show an international presence, the legitimacy of the state at the international level. More recently, there have been ideas, for example, such as land swaps, where a certain number of refugees would be allowed to return to supposedly lands that they had previously owned, and then these lands would be swapped. So with the Palestinian state, so the certain lands in the OPT would become land part of Israel, and these lands where the refugees returned to would become part of the Palestinian state, and as such, Israel's demography in terms of Jewish majority would remain the same. So there have been some ideas such as that. Another idea along this lines was that return would be capped to the first generation of refugees, relatively small number these days, and people and a generation where there would be no prospect of of more children
Mhm.
coming that would change the demography. So in that sense, from a Palestinian perspective, these offers were not serious in terms of the right of return, nor from a legal perspective would they be consistent with the right of return under international law. So,
Okay. Okay, so I have a follow-up question. So Israel also has these Arab citizens, right, with
mhm.
Palestinian origin, and they're now the citizens of Israel, whether they be Muslim, Druze, or Christian. So how was that possible?
Um, Well, not all the rest. Some Palestinians managed to remain after during the 1948 war, and this is a bit of here's a bit of an interesting just some nuance in terms of discussion of return. Some of those who managed to return were displaced inside Israel, Palestinians who became citizens. In some cases, they were allowed to return to their villages, but they were not allowed to repossess their properties. And basically a fear that this would open the floodgates to other claims if they were allowed to return to their properties while allowing them to return to their villages when was seen as some way of trying to establish some a foundation for some relations going forward. Um, but it's important to note that after 19 and this is where this literature that I refer to as the counter archive is quite important. It's important to note that Palestinians continued to be displaced within Israel and expelled from the state in not insignificant numbers in the years after the 1948 war. Most sources say the greater amount of this took place in the first decade until 1959. But there have been other more coercive measures in terms of making living conditions difficult, a practice which Israel later applied to the OPT in order to quote unquote encourage Palestinians to leave. Norma Salha is known for his work on the various plans and proposals that Israel adopted, thought about before 1948, and then put in place in terms of plans and proposals to transfer Palestinians outside the state or exchange them with Jews who continue to live outside Israel. And you can find again these same kind of policies and practices being resurrected after 1967 in the OPT. So they remained because they resisted. They refused to leave. But in some cases, as I noted with ongoing displacement, that was not always possible even after 1948 to stay.
Okay, thank you. So we have another question. It says, given Israel's policy of creating facts on the ground, um,
Mm,
possibly the participant is referring to, Israel's assaults, massacres and everything, and then negotiating based on this reality, along with the ongoing displacement of Palestinians in the West Bank and Gaza, what should be done or can be done to keep the idea of return alive and possible?
mm. Yeah, good question. I mean, it's outside of my purview to suggest what should be done necessarily. That's for Palestinians themselves to determine. But I can point to a number of interesting things going on. For example, I mentioned briefly initiatives in the last 10 years to think about return practically. So there are initiatives, for example, there's an annual, for the last, I think, 5 years, 6 years, there's been an annual competition among architectural students. Um, Palestinian, and I think this last year was open to a broader group of architectural students to design reconstruction plans for Palestinian villages. So thinking practically of what would return look like. And to take a step back from that, when I was uh, oversaw research for Badil Resource Center, one of the things that we initially started at the time of the Camp David negotiations in the early 2000s was what we called go and see visits. This happens for refugees elsewhere. But what we did was we facilitated visits by refugees to their village sites. Now, these villages were destroyed in some places. You can still find ruins. Um, Refugees can identify trees still that they planted. And in order to have a discussion, practically, what would return look like? And these proved to be quite fruitful in terms of a lot of the ideas that just came up through these through these visits and interaction, not only of refugees interacting with places where they came from, but sometimes refugees interacting with Israelis who were now living in these places. I remember one particular incident where we met up with a group of Iraqi Jews who were Israeli citizens, and they began talking, and they said, we understand what this means to you. They say when we saw Baghdad being bombed during the Gulf War, we wept. So there was a sense of like kind of breaking through some of these. Now that's not to say that that's going to change the structures of power, but it shows some of the creative thinking that can happen. So there's very much that's happening along these kind of lines. There's some great marches, Great March of Return, which you likely heard of before events in Gaza, Palestinians marching to the fence around Gaza to raise awareness about and demand for the right to return. All these kinds of, there's so many of these practical things happen. It happens in literature. It happens in so many aspects of the arts. All these are aspects of thinking and beyond beyond the constraints that the structures of power impose on Palestinians and their desire for a return. So,
Okay. Okay, so our next question says, do you think there is any value in reactivating the UNCCP, that is United Nations Conciliation Commission for Palestine, to address current challenges after October 7th? Can it play
mm.
any role in ensuring a ceasefire?
Yeah, that's a good question. On the latter role, ensuring a ceasefire, I don't think it has a role in its current formation or the capacity to do that. I mean, it technically still exists, and the United States, France, and Turkey are the members of this commission. And technically, each of them, their offices in New York, each of them appoint a representative to this commission. What for exactly, I don't know, but I understand that they do this, even though the commission reports every year that it has nothing new to report. Um, uh, I think there is some value in thinking about what role the UNCCP might play, given the fact that it still technically exists, and in the relation to the kinds of political pressures that UNRWA has come under. Um, uh, Now, exactly what that would look like, I mean, what I don't. one of the things that one has to consider at the outset, beyond issues of any changes in its mandate, in terms of a set of activities which it would be instructed to carry out, is that this would have to occur through a General Assembly decision in terms of any changes to its mandate. And also, even before that, I think one has to seriously consider its membership, the US in particular. I mean, if it simply means bringing on a commission that's led by the US, and the UNCCP was throughout its active lifetime in terms of its diplomatic work led by the US, it was basically a vehicle, from what I understand it, reading the historical records, a vehicle for the promotion of US policy in the region. We're not getting very far if it simply continues to be led by the United States, given especially United States policy in relation to Gaza in these last 11 months. So, but I think if one, certainly the Palestinians can marshal a majority in the General Assembly for a resolution that would change both the membership and mandate. And these issues were discussed regularly through the 1960s, even though the commission was not active. But it needs some real serious thinking about, exactly what type of where it could fit within the current constellation of UN organizations on Palestine, the Palestine question, which are numerous, and where could it play a particular role in relation to Palestinian refugees in that constellation. That there hasn't been critical thinking on it, but it's a question that always continues to come up.
Okay, thank you. So another question says it appears that the application of international refugee law strategically benefits Israel's broader objective of ethnic cleansing of Palestinians, even though it ultimately offers protection to them. How can we transform the international refugee regime into an instrument that strategically is more beneficial for Palestinians?
These are good questions. Let me take two parts of this, and I'm not sure I'll provide a direct answer perhaps to the question. But two things that I've been thinking about in relation to the international refugee regime and the convention in particular. I think what we are seeing, and I wanted to go into this in a little bit more detail in the last section of the lecture on registration and refugee definitions. I understand there has been, and I'm sure many of you will have heard are familiar with this critique, especially in the last, it's been particularly strong in the last 10 years or so, but one can find traces of it going all the way back to UNRWA's decision in 1965 to register to the descendants, third generation and subsequent generations of Palestine refugees. There has been this critique that the descendants of refugees are not refugees, made by Israel in UNGA discussions, and also by various Israeli NGOs and some American and other NGOs that are allied with Israeli thinking on this issue. And the argument is basically that under the convention definition, which is almost the same as the one in UNHCR statute, Palestinian refugees wouldn't be refugees. They would not be regarded, or at least the descendants would not be regarded as refugees. And so what appears to be the case here is a case of a demand for bringing UNRWA into line with international norms and standards. But that's obscures what's really happening here. And that's why I think the UNCCP definitions are so important. UNRWA's definition is not different. It's not unique. It's different, but it's not necessarily unique. One can only understand why it's different from UNHCR's definition and the one in the convention when one understands that the UNCCP, its partner body in the Palestinian refugee regime, drafted definitions for the purpose of international protection and solutions which are similar to UNHCR's. Now, they never came into effect because the UNCCP devolved its responsibilities and its refugee office ceased work. So UNRWA's definition is different, but it's different because it had another body that was responsible for those tasks that UNHCR takes on. So what's happening here is the Israelis are using the refugee regime, international refugee regime, and an apparent call to bring UNRWA in line with international standards, in effect, to eliminate Palestinian refugees, to statistically eliminate them, so they're no longer refugees and no longer, they assume, have a right to return. This is also a misplaced argument, because the right to return is not dependent on refugee status per se. The right to return, refugee status is a status that is given to refugees under international refugee law, and it secures them access to basic rights in their countries of refuge. The right to return is found in international human rights law, international humanitarian law, and other bodies of law, and that exists independently of refugee status. So refugee status draws attention to the fact that refugees have a right to return and restores them to what is called the national order of things, or the nation state system. So I think in terms of some of these things need to be made clear, and these arguments that Israel's making around the international refugee regime need to be disassembled and addressed. Now, in terms of, can the international refugee regime be an effective tool? It all depends what you mean by effective. International refugee regime is a humanitarian regime. It's not a political. It regards itself as apolitical. The problem that Palestinian refugees face is a political problem. It's not a humanitarian one, although they have tons of humanitarian issues. But the problem itself, at its root cause, is a political problem. In terms of just the last comment, in terms of how the international refugee regime might be used more effectively, I think it's important to understand historically the way in which power operates and its continuing legacies for refugees. And this has been the focus of a growing body of research that looks at the colonial origins of the convention and UNHCR itself, and the ways in which, in the post-war period after the Second World War, Western states used their power in the United Nations, and these were still imperial and colonial powers, to try to preserve their interests. For example, in putting in clauses in international treaties that would prevent application to colonial territories, or in terms of the Refugee Convention, applying it only to European refugees. And thus we have a situation where all of a sudden refugees only somehow appear with the adoption of or refugees outside of Europe, those in colonial territories who weren't regarded as refugees, somehow disappear in this whole construction. It's necessary to understand how that originated and how that functions today, for example, in states like the United States in particular, which has played a role in generating refugees in countries, or standing in the way in case of Gaza, of refugees being made refugees over and over and over again. One has to understand the way that works and continues to reproduce itself, in order to understand how best to use that regime for Palestinians. Now, that doesn't give you it, but I think that provides kind of a framework of thinking in order to go about some of that critical work, which is really the critical work that needs to be done in terms of strategy. Long answer to, and a roundabout answer perhaps, to that question.
But it's a comprehensive one. I mean, we had two more questions, but I think you have already answered to them, because they're also about the view of the United Nations, basically, to the Palestinian refugees. Thank you very much. I mean, this was quite informative, insightful in that, explanation of almost all the topics around the return issue of Palestinian refugees. And indeed, you know, explaining why we should not have much hope um, for the Palestinians to go back to their lands, unfortunately, because the realities, show the contrary to our hopes, apparently. And the last point you have made, I mean, as we have talked just before the session, about the mindset of this Israeli-Palestinian conflict is indeed a colonial problem, and the approach to Palestinians, even in the humanitarian field, even regarding them being a refugee, has the colonial roots in the history. And again, as we have talked before, uh, I think this approach continues, right? As we have seen in the Abraham Accords. So again, the superpowers or the wealthy countries have been deciding, just instead of a nation, a people. So Terry, thank you very much. We have enjoyed a lot. Thank you so much for your time and for sharing your knowledge with us.
Thank you. If I could just add one very quick comment. I hope that in my presentation, and it wasn't my intention to dispel hope for return to Palestine. There are so many examples, and the fact that Palestinians continue to resist today, 75 years later after 1948, in so many different ways. As Janet Abulugur, as I noted in the last comment on literature, pointed out, um, the fact of exile is that return is being denied by the settler colonial powers, but that doesn't destroy the hope or the fact that in this case refugees continue and Palestinians generally to resist. And I think the fact that this context is slowly being restored or coming back to the fore and understood in new ways, whether through the work of academics and scholars or activists on the ground. I think that and the ways in which the responses to Gaza, including through South Africa's submission to the International Court of Justice, uh, highlight these divisions between the global North and the global South, and in different ways that the global South can play roles. I think these are all reasons, among many, that one can look to and see hope in spite of some very horrific and gloomy
Mhm.
news that we've seen every day for the last 11 months in particular. So I
Yeah.
hope to
Okay.
end on a note of hope in that sense.
Okay. So it's my pessimism, but let's keep our hopes alive. And thank you again. Thank you very much. And thank you everybody for being with us tonight. Comes